Hello, Marco, and hello, Paolo. It's very nice to see both of you here today.
Hi, Maya. Thanks for
Thanks
having
for
me
having
back.
us.
Well, I'm very happy to have both of you. I know that you two are very good friends. You've been friends for a very long time, and you're both very good criminal defense lawyers, and you've been practicing even before the pandemic. So you're senior lawyers, you do trials, you're both very busy. So you know everything that's going on in the day-to-day life in court. Marco, you practice in the GTA, and Paulo, you're based in the East region. So that's nice to give us a perspective of what's going on. But also right now, we're in a time where there are so many new changes in the laws, in criminal law, and it doesn't seem like they're very good for the defense. So I wanted to talk to you guys about that. I'll let it up to you guys to have this discussion. Start with whatever you want to start with, whether it's the legislative changes or the practice. It's up to you.
Where should we start, Marco? Get the
Go,
laundry,
go
get
ahead,
the
Paolo.
laundry list out.
You had the laundry list, so we can get started.
Well, I guess let's start with bail, right? That's
Yeah,
the word. That's the thing everybody's talking about, right? And
right.
I think what we've seen over the past half decade is just a very strong pendulum swing towards a crime control type of approach to dealing with bail. And I don't think obviously we've got the new legislation. I haven't gotten a chance to go through it with a fine tooth comb, but it's going to make it more and more difficult for our clients to get bail, and we all know what's going to happen as a result with increased numbers in the jails and the facilities that, as of this point, can't handle it. Right, so I think it's going to get a lot worse. Now, luckily, we've got the new practice directive um, with respect to bails, which should have been in effect for a long time. Other than now, 2026, we're just dealing with that issue. But it's kind of refreshing to at least see that the procedural aspect is going to be the way it should be, but legally, our clients seem to be in a little bit of trouble getting out now.
I just want to
Yeah. Sorry, go
sorry,
ahead, Maya. No.
just because I mean some of the things that Paulo just mentioned about there being stricter bail laws that are coming into effect and the jail capacity. I mean, it just feels like there's an inconsistency between the changes and the current situation. Like we want more people in jail, but we know that our jails are struggling. We have no space. So it's just inconsistent. We also have this new practice direction for bails to become more efficient and waste less time. But then we have these legislative changes where there's more reverse onus, there's more stuff to do. So it just feels like there is a discrepancy between the new laws and the reality of what we're dealing with, right? Like, I don't know, am I hallucinating?
Yeah, that no, that but that's look, the politicians make the laws to satisfy their political needs, right? So they want to hit these high notes and it makes it sound so great. But the problem is the trickle down effect, it doesn't happen. It doesn't materialize in the practical realities. And then basically the system gets continuously pulled thinner and thinner that it's going to snap, right? And so that's why we end up getting to these situations where the defense lawyers have to bring constitutional challenges, or then you hear about jail conditions warranting all this extra dead time, and it's all skewed because, well, you want to make laws more stringent, you don't keep up with all the other infrastructure that's required to implement those laws, and so the response has to come from somewhere. And so then the response comes from us as defense counsel challenging these issues, bringing these issues to light in court, and asking the judge to consider how these issues affect, justice. And so, this is the difference between, you know, ivory tower politicians who want to
Mm.
make laws to satisfy and appease voters and get votes against the everyday practice in criminal court. And really, it doesn't come together until one of the people who are usually in support of these, political moves gets charged, and then they come in and they're like, "Oh, how come I don't get? I heard that you get bail. Murderers are getting released on bail, but
Yeah.
I'm not getting out because there's a reverse onus now on intimate partner violence, and my wife accused me of a domestic assault." And then it becomes that you have to explain to these people one at a time how what they're telling you in the media, what they tell you in the politics, is not the reality of how things unfold over here, right?
Yeah,
That's the
we're
way I
seeing
see
that
it.
more and more. We're seeing that more and more often in terms of practice with people who are just, until they're actually charged and until either themselves or a loved one is involved in the criminal justice system, they have absolutely no idea what is going on, right? And I mean, at the end of the day, on Marco's point, you know, for these politicians who are, you know, enacting these tougher laws, and then when it trickles down to the actual practice and things are just going awry, right? For example, detention centers, right?
Hmm.
Overcrowding. Well, judges are getting remedies for that, right? Politicians can take cover and they say, well, what's the first response? They'll say these liberal judges, right? These activist judges. They'll go after the judges,
Yeah.
right? And it just and it'll give them cover and say, hey, look, we're trying to do what we want to do. It's these other people who just who aren't subject to the will of the people who are interfering.
But
Yeah,
it
well, they
just,
don't want to
yeah.
invest. They don't want to invest the resources, right? They
Exactly.
don't want to
Yeah.
invest the
Right.
resources in the implementation. And we can start from, I think what's considered, and Paul's going to laugh because he knows what I'm going to say here, but the universally most disliked decision from the Supreme Court in the history of Canada has to be Jordan,
Yeah.
right? I don't think there's
100%.
I hate this decision.
100%.
one person,
Yeah.
defense, crown, judges, trial coordinators, everybody hates Jordan. The media, journalism.
But
There's not one person who stands up and says
Paulo,
Jordan was a
Marco,
good decision.
isn't Jordan and 11B supposed to be an accused right? Like, isn't it a right for the accused to have a trial within a reasonable time? But it just feels like it is used against the accused. Like it's weaponized
Right.
against the accused. Like it's a nightmare for the defense, Jordan, when it's supposed to help the defense.
It's the classic example of the disconnect between, you know, these high branches of government, Supreme Court being the judiciary, versus the practical realities of how things play out in real life,
Yeah.
right? It's the disconnect. The same with the disconnect between the executive branch of the federal government making laws that don't impact they don't they're disconnected from the practical realities of how things play out. So, yeah, great timelines, 18 months, 30 months, these are firm, these are fixed, but there's so many other things to consider
Mhm.
So many
in
variables.
variables that, like, they're so far removed from how things actually happen in court that, like, of course this is not going to be tenable, and in practice it's not going to be tenable. And so that's why these broad sweeping laws they're used against us, because you almost feel like they're being spiteful. They're saying, well, we're told we have to do this, so we'll give you a trial date next week. Okay, but how does that comply with my 30-day charter application? I was supposed to go back in time and file it, because now you're going to give me a 30 days
Oh,
because
and
of
they
that.
give you that date sometimes even when the Crown did not provide full disclosure. And it's like, it's not their problem. Like, we have a date and, you have to go do a trial. We don't want to hear anything about that. And sometimes, like they force us to set trial dates even when we're still asking for disclosure and we're still missing substantial disclosure. I mean, that's my experience in these. I'm pretty sure, Paulo, you had the same experience as well.
Yeah, absolutely. I mean, we get pushed all the time as defense counsel, right?
Hmm.
Because there's this mythical number that the courts and the crown want to control as much as possible, and we're on the other end of the stick, right? Because we're the only ones that, at least they think, are working contrary to that, right? Of course, I want to have my client's trial within a reasonable amount of time. Of course, I don't want to delay things. Of course, I wish my calendar was more open, but it's not. That's the reality of it, right? But it just seems as though defense counsel are always, at the bottom of the hill, and we know what happens when crap rolls down a hill, right? We get it. So I just think that there's a lot of pressure being placed upon us, and it just seems as though everybody's working against us, right? You mentioned these dates, right? We, for a time period, called them fake dates because all it would be stacking,
Yeah.
trial on trial on trial, and the same thing would happen. But God forbid you turn it down. Well, that doesn't count for delay, right? So yeah, Mark was right. Jordan's a horrible, horrible
Yeah.
decision that I
But
don't
the
think.
reality is, again, like all these laws, what they do is they bank on the limited resources of the individual, right? Like if we really break it down to its essence, that's what it banks on. It banks on, let's break the back of the accused. Okay, we'll offer you a day next week. Okay, Mr. Accused, pay me for the trial. He pays me, I show up. Oh, you're stacked, it gets adjourned. Next day, okay, Mr. Accused, pay me again for the next day, right? He's stacked, doesn't get reached again. Next. And so the court is banking on eventually either the accused runs out of money or he's not going to pay. All these dates get kicked over, or the defense lawyer is going to be paying for all these dates out of their own pocket. Whatever it is, it really creates this disparity between rich defendants and poor defendants, right? And like the example, and Maya and I were talking, Paulo, before you came on, the example that I like to draw analogous to this is if we look at the history of impaired driving law in Canada, right? If you just go to the criminal code and you check the annotations of the impaired driving provisions, you can see that each and every single possible legal argument of known to man has been advanced in defense of those cases because obviously given the volume, the number of accused persons with resources can afford to attack every single aspect of that area of law, such that there were numerous defenses available to accused over the years that have slowly been shut down by the state. But the reason why that exists is because it attracted clients with the resources to be able to advance that sort of litigation. But that is a very unique provision. The rest of the criminal code gets everybody, and then if you don't have the resources to challenge it, if you don't have the resources to advance these arguments, then yeah, your client's gonna be convicted one way or another because it's all fake dates. It's all show up next week to do a trial. Sure, I'll show up next week.
Right.
My
And
client has
and
the
add on
resources.
and add on the other issue. God forbid you're in custody, right?
Hmm.
You're in
Right.
custody in a detention center that is inhumane. Like, yeah, you're going to browbeat the accused into resolving. You're going to browbeat them into giving up.
Well, and it causes a lot of, I find sometimes friction between the lawyer and the client because the client gets frustrated. The only person they can bring their frustration on is the lawyer. And then you have a breakdown sometimes in the solicitor-client relationship. And then that causes more delay. Every time there's a change of counsel, how is that going to be good in terms of Jordan delays? Because you have to give the new lawyer a chance to get to know the file and to like it's just like a vicious cycle that's never ending, and it just seems to be counterproductive. So, my question here is, does anyone understand what the ultimate goal is like behind these changes? Because it doesn't seem like it's helping anything or anyone. It's certainly not helping our clients. So, I don't see where this is going.
I mean,
I think.
I mean, the
Go
federal
ahead,
government's
Paul.
trying to they're just trying to legislate 11B out, right? I mean, the new provisions they put in with 24 1, right? It's crazy. It's crazy to think that this is where we're at, where,
Mhm.
the federal government since 1982, since the enactment of the charter, had the ability to legislate, right? They had the ability to legislate what 11B is all about, what 24 1 is all about, and they didn't take the chance up until now. So now all of a sudden they're coming in and you're going to see a piece by piece demolishing of, what the right to a trial within a reasonable amount of time is.
And the irony of it all to me is that a lot of it is the result of, I don't want to use, maybe I'll use this word out of turn, but judicial advocacy, right?
Mhm.
Like when the judges wanted more judges appointed in the Superior Court, suddenly you see a whole bunch of 11B decisions in our favor. When the Supreme Court was fed up with Askov and Moran, you see a broad sweeping Jordan, Cody. It's judges making these decisions, and as a result of the judges making these decisions, and I don't want to say it to their benefit, but to the benefit of what they believe is to the benefit of the justice system, more judges, quicker turnaround time, this, that, and the other, rather than taking the judge's decisions and saying, okay, how do we put these into practice? Let's just change the law to like ignore those decisions rather than invest in more courtrooms, more courthouses, more court staff, better paid court staff. Because that's the reality. Like a lot of people don't want the court staff job because it's just not a great job, right? It's a hard job. It doesn't pay that well. And so, there then if you input into the resources of the justice system, better courts, better staff, better jails, bigger
But
jails,
Marco,
more
how
jails,
about less
whatever.
criminalization? Like, why do we overcharge? Why can't we just resolve without having to force people to plead guilty to everything? Like, that's another problem that we also see in the system is that there are not everything has to become a criminal case. Some assault, simple assault cases are really very funny. I mean, not to say that, but sometimes they're
Mm.
really, they're not every assault is a serious assault, and not everyone, like some of them, honestly, sometimes assault with a weapon, the weapon was a teddy bear. I
Yeah,
mean,
Well, like
yeah,
in BC, they're really implementing this pre-charge screening
yeah.
that, clients are being told that they're being investigated. They hire a lawyer, and then the lawyers can negotiate. The crown attorney gets assigned to the pre-charge, and the lawyer and the crown attorney can negotiate it even before a charge gets laid. I mean,
Mhm.
that to me is the most basic step to take in our system. But of course, they're met with resistance by the police in Ontario, because Ontario police are saying, well, we don't want our discretion fettered by crown attorneys at our charging stage, but they don't exercise their discretion. Some do, some don't, but typically they charge first and
Yeah.
close their eyes to the case later.
yeah. And I think what you've seen to compound the problem is that in the last, I don't know, Marco, maybe 5, 6, 7 years, there's been a significant loss in terms of crown discretion, whether it's because of the culture from the top down, whether it's because of the crown policy manual, whether it's because you're dealing now with much younger crowns who don't have the mentorship experience. It just seems that that discretion has been lost even at the crown level to get rid of what shouldn't be seen
Yeah.
inside of the courtroom.
Right. And then what that does is it leads to a over volume of files on each crown's desk. A lot of the more senior crowns are basically, I mean, there's no official numbers. I'm just talking from anecdotal experience from people I know in the crown's office. They're just basically saying, forget it. Let me sit con here. Let me leave there. I'll go to the labor, Ministry of Labor. I'll go to Ministry of the Environment. They just leave the prosecution office because they're just overworked and they don't want to do that much work because they're not happy with how the system is. Young crowds come in. They don't know how to navigate a file, and then the deputies are just left by saying, let's run it, just run it
Just
and
run
see
it.
what happens. And so really what ends up happening is a significantly large amount of cases in the trial stream.
But it's so stupid because we then now have these projects like what we're having, the special JPT resolution projects where we're trying to resolve everything. And so they're giving us some better deals that they could have given us since day one. It's like, well, why don't you just have this attitude at the beginning? Like, why are we now at a point where we need to create this special? And it's good, like, it's good if we can get rid of some cases, but why is that not the attitude at the beginning? Why now when it's just too late and we have too many cases and we just want to get rid of all these cases? Like it just doesn't make sense. What I'm finding here is like it's hard to understand what the logic is in the system.
Well, they want to see if somebody's going to break, right? Though
Yeah.
it's a game of chicken until somebody gives in. That's the way I see it, Paulo.
Absolutely, right? It's run everything, and then you're gonna get your blitz JPTs and your blitz trial courts and your blitz plea courts to take some of that pressure off, and then you know 6 months later you're right back at it, right? And you know the crown, you know the crown attorney's office doesn't feel or doesn't have to deal with the same consequences that we as defense lawyers
Yeah.
have to via our clients, right?
Yeah.
Mhm.
The Crown has nothing to lose by running a case. They don't get cost orders against them.
Mhm.
They don't. they don't suffer as a result of running a case, right? Whereas we're in a different position,
Yeah.
and we have to represent someone.
The other thing too is eh, it's all COVID. What COVID did is just expose how frail the system is, right? COVID comes along, and all of a sudden they're handing out peace bonds like candy. They're, everybody's getting discharges. Things are moving along. There's been no backlash as of that's come out as a result of that approach taken during COVID. It's not as though they're giving all these statistics saying all those peace bonds resulted in recidivism or all those discharges of like there's nothing. They were able to clean house because of COVID because it exposed the frailties in the system. But then the moment that kind of went away, it's like let's just go back to our old ways.
Right
Yeah.
We
back,
didn't
right
learn,
back,
and we just went back to our old ways.
right,
And
Convicting
right,
and on
everyone.
right
top of
back.
it, double down and make it even worse, right? Like
Yeah.
yeah, it became even worse.
Well, Marco, you and I had this conversation about how criminal law is no longer about litigation; it's about bureaucracy. And that's what COVID has caused is like, you want to do this, well, you got to fill out this form, you got to do this, you got to do this, you got to take this step, you got to take this step. It's become, the trial itself has become secondary to everything in the run up to getting that trial date, and it just sucks so much resources from all sides in our system.
What I think it's also done is that it's all of this administrative stuff that we have to do in order to comply with all of these protocols that are in place, the deadlines, scheduling this, trial coordinators, all this nonsense. I call it nonsense because it's done is it has weaned out, I think, a lot of the senior members of the bar, right? Unless they have diligent young assistants or staff members, admin staff that can stay on top of all this. It's kind of weaned them all out. I find they just don't want to deal with it. And then but I also find that it's breaking the backs of the young lawyers too, who are trying to get in there and have to spend a good portion of their time complying with administrative issues. And then if you don't comply with them, you're the one who gets in trouble in court because you didn't comply with it. Meanwhile, I haven't received a crown, factum or response before the day of in provincial court in years. So we're the ones being criticized if we don't comply with the protocols that are in place. But there's just so many that if you're a young lawyer, unless you have an assistant or a staff member that can assist you with it, how are you ever going to keep up with all that?
Right. And then added trying to actually practice and learn the law and do what it is that you're supposed to be doing, right? You're dealing with all this other crap, and it's affecting uh the level of advocacy, the level of confidence, and the ability for younger defense lawyers, I think, to do the job that they are able to do if they weren't stuck in this bureaucracy quagmire.
Well, the other
And
thing,
really, to whose benefit? It's to the benefit to save the appearance of fairness and justice that your clients
Right.
look. The court's doing everything we can to get your guy a trial in a reasonable amount of time. Sure, by giving me 17 different
yeah,
forms
I
to
mean,
fill
but
out.
that's the thing, like how is it beneficial to the accused if there is a trial date, but their lawyer doesn't have the opportunity to get ready? I mean, what's more important for the accused is that the lawyer be prepared. But if, like the court is ready, but we don't give your lawyer enough time to be ready because of all these bureaucratic things that they have to do. I mean, just to bring forward is such a pain. Like you have to, all these procedures that we have to do, like an order to produce, bring forward application, like everything is a lot of work, a lot of things that the defense have to do. Um, it just adds more to the pressure. But on COVID, though, because you guys raised the issue of COVID. So, COVID, yes, there's this administrative aspect and the stacking and everything, but it also changed the daily lives of how we live as criminal defense lawyers. I mean, Paulo knows how in the East region we used to have our Tim Hortons cafeteria before COVID, and that's where all the criminal defense lawyers would hang out on a daily basis. We don't have that anymore, and sadly, like now, I see people in court. I don't recognize anyone. I don't know who they are. I don't know their names. I don't know if they're lawyers or students, or I don't know. And that was not the case before COVID. I used to know everyone, everybody, especially in the East. It's a smaller bar. But COVID also changed the way we like our social interactions with each other. So let's talk a bit about that because that's also a problem.
Yeah. Marco, are you okay if I go first? Just to
Yeah.
add on to that East region. I mean, look, I started practicing in 2007, and even before that, when I was doing my articles, the best education I could get was to sit around at we used to have an independent like food place in the atrium at the
Cafeteria, yeah.
courthouse, right? The
Yeah.
cafeteria, right?
Yeah.
Before it was Tim Hortons.
Yeah.
And let me tell you, that's where you get your education,
Yeah.
right? Where you've got your senior lawyers talking about cases, banding about ideas, just like we would do
And
now, right? Where we
networking,
would sit
like
at the
that's
table.
how you get to know
Absolutely.
everyone. Yeah.
But that's gone. And I recall talking about this previously that there's this loss of camaraderie, there's this loss of mentorship that's come as a result of COVID and things going online, and that mentorship is just not there anymore, right? So yeah, I've unfortunately seen a decline in that.
Yeah, I agree, but I also think that we have a certain level of responsibility. Like, I mean, when I'm in court, especially if I'm in provincial court, in Superior Court in Toronto, it's pretty customary to have a good camaraderie with the other lawyers that are there because the lawyers' lounge there is a pretty much of a hub, and everybody kind of gets there early, gets changed, and chit chats around. But in the provincial court, you know, as a more experienced lawyer, I'm not averse to just chit chatting with younger people, meeting new people, people that I've never met before, asking them what their case is about. I think the onus is on us a little bit as the more senior members of the bar to engage the younger lawyers. They might be a little bit intimidated or just not comfortable because they haven't been brought up in that environment, right? Like the point that Maya is making is before COVID it was one way, after COVID is another. But if you came into this profession during COVID, and that's a lot of people now, 6 years worth of people. You didn't know how it was before. How would you know how it should be? Right. So they look to people like us who've been around longer. And, if you see somebody in the lawyer's lounge, it doesn't take anything to say, hey, what do you got today? And then they'll say, oh, I got a domestic. Oh, yeah, who's your judge? Oh, it's Judge so and so. And then, the little chit chat that starts, if you take the lead, then you can kind of recreate that momentum that we had, and I try to do it. I mean, obviously, it's more limited because I'm not available as much as I used to be when it was before COVID. But when I am there, I want to start those conversations. I do the same thing with when I have students with me or associates with me. I introduce them to people all the time. I want them to meet the other lawyers if there's people that I know, so that then because your network is important, right? Your network is your net worth, right? That's what I like to say is that the more people that your network gets developed, then you can develop a value into that, right? So there's nothing wrong with that. So
Right.
take I encourage people out there, especially if you were around before COVID, to behave as though you're acting, behave as if it was before COVID, and start those discussions and those conversations.
But the thing, so I don't know how it is in Toronto, but in the East, it was a little bit different. I mean, that's why Paolo knows how it was. Like now, even when you go to court, Marco, in Ottawa, for example, it's empty. I mean, it's not like it used to be. I mean, before, any day you would go to court, you would see almost everybody, all the senior, junior, like everybody was there all the time because of that cafeteria, and people would just go and chat sometimes. And that was so nice because that's how you get to connect with people. But now, even when I go to court, it's empty. Like sometimes, I'm in the middle of a trial and something comes up. Sometimes there's nobody that I can go and ask to. So I have to email or call someone to ask for help. Whereas before, I just had to go to the courthouse and there was for sure at least two or three other lawyers senior that I can ask for help. And maybe that's more in the East, but it's very different. It's really sometimes like a ghost house. There are days when it's like that.
I think that it's like that generally. Like, I mean, Brampton's very busy, but I mean,
Hmm.
generally there's less people. But if you're one of the people that are there
Yeah.
and you see other people that are there, like if you network and discuss with other people or just chit chat like that, you can kind of bridge that. Like, look, I was in Ottawa, as you know, for a month back in 2024. I felt that, over the course of a month, I bumped into a lot of people. I met a bunch of people. I didn't meet a large volume of people at once, that I agree with
Yeah.
you. But if you're there like consistently, you cross paths with people and you get to know people. I mean, obviously, I have my friends that are there who then introduce me to other people, and then you just kind of meet people. But if you're there enough, yeah, you cross paths with people. I know it's not the same. It's different, but even though it's different, I think we can still make efforts to create those relationships because it's much nicer if I get a lot of cold call emails and phone calls for legal advice, trial advice, that sort of stuff. It's so much nicer when it's somebody that I've spoken to face than it's just some random email, which I've gotten as well, right?
Right, right.
Well, one thing I just wonder because, we hear the government talking about investing in new jails and more jails and more. Why not? Don't they make it mandatory to have a cafeteria in every, like courthouse? I think like that's good for the defense. I guess that's why they're not interested in doing that. But it should be. It's important, I find. Like criminal defense lawyers, especially, first of all, I don't know a single criminal defense lawyer who doesn't drink coffee. And I find like it's the best way to get us together, at least, like in these, it should be mandatory. Like, why don't we
Well,
demand that they build a cafeteria in every courthouse?
when I retire in another 20 years, I'm going to open up a nice little espresso shop downstairs,
Yeah, well,
I'll
why
get
not
my, I'll
now
get,
though?
get my,
It's the price. I heard I discussed actually this is an issue it's interesting that you raised it because obviously they all have the facility. It's
Yeah,
that all government buildings have a certain
least
they have
amount,
to keep what's that?
the certain amount that they have to charge.
They have to charge a flat rate across the board, right? And so, this, mom and pop cafeteria can afford to stay open in a courthouse that only runs on basically until 4:30 every day and may or may not generate the volume that it once did. As you said, without set day court, the traffic in the building has gone down significantly. And then without that traffic, they're not making the sales that they need to stay open. And that's why one by one they've closed. Even the ones that had Tim Hortons, like Oshawa had Tim Hortons, even the Tim Hortons in Oshawa couldn't stay open because there isn't the traffic in the building.
Well,
I
out of,
find the ones with the Superior Court can stay
mhm.
open because they feed the juries. So I think they get a lot of
Yeah,
money that way.
yeah,
But I don't think that's a slight to the defense bar. I think that if anything, it's the court staff that suffer the most as a result of not having a coffee shop in there because they can't even buy themselves a sandwich. They have to
yeah.
leave. It's terrible. Anyways.
Well, I mean, I know we've been talking about a lot of problems, and you know me, Marco, I don't like to be pessimistic. If we
No, you
just
like
want
to not be you like to be pessimistic for 42 minutes, and
No,
then
but
in the
I mean,
last minutes you
first,
tell
well,
us
no, but the
something good.
sunshine.
situation, because the situation is pessimistic right now. I mean, like these new changes that are coming into effect and that are already in effect now are not very good, to be honest. But is there hope? I mean, I'm asking both of you, like, or what can we do for things to get better?
Listen, we've look at we've gone through significant legislative changes in the last decade, including, for example, the sexual assault laws, right?
Yeah,
And we persevere. As defense counsel, we always persevere. Whether or not there's hope that things change at the end of the day, that's one thing. But we adapt, we persevere, we still represent our clients to the best of our abilities using the tools that we have. And that's what makes us special. So is there hope? Yeah, there's hope. Is there hope for a change to go back to where it was? Absolutely not. I think as more and more time elapses, we're going to continue moving farther and farther to the right when it comes to dealing with criminal law in this country.
Yeah, I think we just got to use these as opportunities to do our job and challenge the legislations that we find are unconstitutional. I know that not every client has the resources to do that. I know that not every case is open or amenable to that. But the ones that do and the time when they do arise, we got to take those steps. I think we have to also use these as an opportunity for that sort of litigation. I think it's hard because everybody's got to make a living, and this is a lot of extra work that nobody wants to do. But I find that when I have, like, I like to surround myself with young lawyers, motivated lawyers, lawyers that are still like they're in it for the right reasons, and those ones kind of push you to like don't give in so easily. Let's make these fights. Let's put in that extra work that might be out of your own pocket to make a change here and fight this or challenge this legislation or challenge this. And you know what? There's enough of us in the bar across this country that can and will do that. And if each one of us just does a small part every time, then the law will develop the way we want it to. Look, we got it here. Like, let's not be delusional. The government changes the law and responds to the actions of the defense, right? The reasons why we're here is because we've challenged the legislations, we've challenged the Mississippi, we challenged the behavior of the police, we challenge these things, and for one way or another, the government responds, and it always responds to make it another obstacle for us, and then we find a way through that obstacle, over that obstacle, around that obstacle, and we get to where we got to go. So just continue to find your way through it. If you're not motivated to do that, then it does become very depressing because it feels like every single day we come to work to be in arguments with people. And that's it. It's hard.
All right. Well, hopefully, let's hope for the best then. We'll see how these new changes will play out. I know we're still at the very early stages of these new changes, but hopefully some positive will come out of it, and maybe you guys will come back again and we'll see. Maybe we'll be having a completely different conversation. Maybe it will be optimistic. Who knows? So we'll see. But thank you
I
so
was gonna
much. Yeah, go ahead,
I
Paul.
was gonna say, I think Marco and I are secretly hoping that they just legislate out 11B so we never have to worry about it
Yeah.
again.
I'm
Wishful
not
thinking.
secretly open. I told you, but like I'll just say this, and like some people judge this. I might have mentioned it the last time around, but 11B had a significant effect on my personal practice. I've had, as part of my retainer agreement, I get a limited 11B waiver from all my clients to allow me to schedule trial dates on my schedule so as to not get into these, we can give you a trial next week or wedge it in between two major cases or whatever, because it hasn't been good um, for my practice and my health, my mental health,
Mhm.
to go from try to keep to put my clients' 11B rights against my own personal interests. So I ask my clients at the outset to acknowledge an 11B waiver to allow me to schedule trial dates on my schedule as I see fit. Limited waiver. If 11B materializes naturally, then so be it. But I also, otherwise, they don't have to retain me. They can go retain another lawyer who has
Yeah.
more availability. Because I think that it's only fair to the client to know my schedule, how busy I am, and how unlikely it is that if they're really, really concerned about having a trial within a reasonable amount of time, it's maybe going to be unlikely that they're going to get it if they retain me. And being open and fair with the client at the outset has been good because it's kind of taken me out of this 11B kind of game. Where it's kind of backfired on me is sometimes the courts are not happy with these waivers. Sometimes they bring me in, well, why are you waiving till next year? Why can't we squeeze it in earlier? And then you get into these 11B courts where they call me back in to try to do it sooner because my schedule is, and they just wanna, again, I don't know if it's for the purpose of the record. So I end up doing 2 or 3 extra appearances just to justify that waiver, make sure my client understands it. But, you know, at the end of the day, as we've all identified it, what's the point of this 11B? Is it true? Is it a true 11B when the courts are saying, well, we can give you a date next week? What are we doing here?
Right.
Right. Then I got to go explain this to my client that well, they can give you a trial next week. I'll take it. Okay, but I'm not available. Also, it's your
Well, it's like
fault
the
that my
crown is
trial.
always ready, right? The crown is always
Right.
ready, but then when we
Right.
get to the day off, sometimes they're not ready when they just said
Yeah.
on the record that they were.
Yeah, you got to explain to your client, oh, I'm not available. Oh, you're not available, so my 11B rights are being infringed. I could get this case thrown out, but because you're not available, I'm stuck. So I don't want to have to deal with that when it happens. I deal with it at the outset with the limited waiver so that I can schedule it with a waiver, and that way it's on my schedule, and then that's it, right? And the clients are aware, and it's comprehensive. It's a 2-page document that they have to read and sign and acknowledge, and that's it. Or else go hire Paulo. He's got nothing to do, right? So
Or, AI will
Warrior
just
Dog.
AI will replace everybody, like that's what
yeah,
I feel like is gonna
Yeah.
happen. We won't be working anymore. We'll just be robots and replaced by machines. So we'll see.
Well, maybe that means the crowns will answer their emails now, but
Yeah.
we'll see.
yeah.
Well, I want to
All right,
thank you
Maya.
though, guys, so much for taking the
You're
time.
welcome.
Like I know you have very busy schedules, but it was very nice to chat with you. And I hope
You
that we
too.
can have this again soon and maybe things will be better. Let's be optimistic.
Thanks,
Okay.
Maya.
Thank you
All
so
Appreciate
right.
it.
much.
Thank you.
Bye bye.
Take care.